Arthur Yates and Co. have been one of the most prominent seeds and gardening products companies in Australia for many decades. You can still easily find their products in your local hardware store or nursery. During the Second World War, one real issue was ensuring that Australia could feed her own people and also grow food which would contribute to the war effort. The government passed the National Security Vegetable Seeds Regulations. Their objects were to ensure, for the purposes of the defence of the Commonwealth and the effectual prosecution of the war, that an adequate supply of vegetable seeds is available in Australia, that those seeds are true to type and of a satisfactory standard of purity and germination, and that those seeds are effectively distributed. The regulations created a committee, the Vegetable Seeds Committee, which was empowered by order to control and regulate the processing, treatment, distribution, and disposal of vegetable seeds. The committee set itself up as not just a regulator, but a trader of seeds. And then, according to Yates, they began to issue orders preventing private companies such as Yates from buying and selling particular seeds. According to Yates, the committee didn't do this for the purposes set out in the legislation, but rather to give the committee a competitive advantage against those private companies. Yates challenged the decision. This case is quite a complicated one to explain from a procedural perspective because what actually came before the High Court was a dispute about whether certain clauses in the Statement of Claim should be struck out or not. But in dealing with that question, the High Court touched on some of the substantive underlying issues. Justice Williams said, if a power is conferred in terms which require it to be used only for a particular purpose, then the use of that power for any other purpose cannot be justified. It is implied that if the committee had used its powers to further its own success rather than to help win the war, its decision would have been invalid because it would have been made for an improper purpose. We find that rule in its modern form in Section 52C of the Administrative Decisions Judicial Review Act, which allows the review of an exercise of power for a purpose other than a purpose for which the power is conferred.